Today we are hearing arguments in the case of the Queen on the application of Fatmah Mahmoud and the Commissioner of Police for the Metropolis. Can we hear first from counsel for the appellant?
May it please the Court, my name is Thompson and I appear with my learned colleague Peter O'Loughlin for the appellant. My learned friend Miss Deborah Moss appears with Miss Joanna Shaw for the respondent. This is a case that illustrates precisely why this Court should find that this law is incompatible with the European Convention on Human Rights. I invite the Court to consider Miss Mahmoud's position in this case. She's an innocent English woman going about her daily business, shopping for the family's groceries, when, on no reasonable grounds, but for the power under this Act, she's stopped by police. However, instead of being allowed to return home to her husband and children, she's kept by the roadside to wait for a female police officer because she objects to being searched by the male police officers. This woman was not suspected of any wrongdoing, and her possessions had already been searched without yielding anything nefarious.
This reference to extended periods of time, I'm not sure if that's entirely accurate. The stop and search procedure in most instances, you would appreciate, will take no more than a few minutes. There is no confinement, there's no detention, there's no removal, there's no arrest. How does that constitute a deprivation of liberty?
There can be a number of instances where it could be imagined that somebody would be detained for a similar period as Miss Mahmoud. In particular, many women, not just women of the Muslim faith, would feel very uncomfortable being given a pat-down search by male police officers. It's quite an invasive search. It involves the placing of hands on somebody's body.
Is your claim is that every incident of stop and search under Section 60 is in principle, Section 60 in principle is incompatible, or just certain aspects, certain cases aren't? Because if your argument is that this is in principle wrong, then the argument is not that Roberts should be distinguished, but it's that Roberts is wrong.
Yes, it is my principal submission that this Court is not bound by Roberts and that this Court should take the contrary view. It is my submission that Section 60 is incompatible with Article 5 in that it has the ability to deprive citizens of their right to liberty, as is exemplified in the case of Miss Mahmoud.
Parliament enacted Section 60 to address extremely grave issues of public safety and prevent criminal conduct. It's undeniable that the exercise of these powers on occasion may lead to inconvenience, embarrassment, and even distress for individuals. This is regrettable. However, it does not mean that the statutory scheme, which is necessary, is unlawful.
Your submission that what matters is whether it's brief, whether it's unobtrusive, whether it's superficial. But this, on my reading of the judgments, is not what matters. What matters is how random the search is and the extent of the police powers. And in fact, if Roberts, which was on Section 60, Lord Justice Kay said Article 8 is engaged And I simply refer to the potential humiliation and embarrassment of being subjected to a random search in a public place by a police officer who need not have reasonable suspicion of criminality in any form. And the same approach is adopted in Gillen and in Colon, in which they say that it's about being stopped anywhere at any time without notice, without any choice as to whether to or not to submit. And on that basis, it's engaged. So really, why does it matter whether it's brief or unobtrusive? It's the fact that they've been stopped and that they can't object to it that matters, surely.
If every time someone conducts an airport search, it's deemed an interference or prima facie interference with Article 8, I think that could lead to further public policy complications. I would call this de minimis. I think it's such a light search that it just doesn't engage with somebody's right to privacy or to bodily integrity.
So, Ms. Moss, surely it'd be quite easy to distinguish an airport search style situation on the basis that when you enter an airport, by doing so you're consenting to being searched at some point. Whereas if you're going about your daily life in the town where you live, that's not really the case.
To my mind, there's nothing in the wording of Article 8 or 9 that would lead to such a distinction. I would say that the decision as to whether to go into the airport and the decision and being stopped without a decision pertains more to Article 5, which we've discussed, or to potential detention, but I wouldn't say that it's relevant to interference or potential interference with
I think the European Court on Human Rights might disagree with you based on their judgment in Gillen. They ruled on Article 8 grounds, and they rejected this analogy to airport searching.
The court here, the present court, is of course at liberty, whilst taking into account the ruling of the European Court of Human Rights, to look instead to Lord Bingham's approach in the House of Lords decision. I would argue that Gillen isn't binding, including because, for the reason I've given, obviously under the Human Rights Act, but also because it does deal with Section 44 rather than Section 60. There is a further distinction to be drawn there.
Thank you. The court will reserve its judgment.